All right, we are recording. So good morning, good morning, good morning. It is November 9th, 2023, and we are going to tackle a different subject today that I'll get to in a minute. But before I do, normal caveats apply. First off, invite all your friends. We're lonely. We like your friends. Your friends will like us. Have them join our group. Be popular amongst your peers. Recommend our group and our landlord-tenant group to everyone in the knowledge that the more people that join, the more useful it is for everyone. So it's just one of those win-wins. Of course, you have to be a professional. Please make sure you're a requisite professional. Please apply with your professional status, and then we would love to have you as part of the group. Second point is what I always point out, which is that though our forums are private, our videos are public. Anything that is said on these forums are going to be recorded, will be put out, and are publicly available. So please be advised about that. I would introduce myself the way I normally introduce our guest speakers, but given that I'm the one who's speaking, it seems like it would be a bit of an ego problem if I did. So I'm not going to do that. Instead, I'm just going to talk about what we're going to turn our attention to today and kind of launch right into it. Being a real estate lawyer means understanding several facets of law, and it means understanding the conveyance itself. It means understanding the common law, and it also means understanding Ontario's body of legislation that pertains to real estate. If you think about it, real estate is a major component of what people's assets are. In fact, for most people, it's the major component, and accordingly, it will come as no one's surprise that Ontario has turned quite a bit of attention to the regulation of real estate, not ready to just leave the common law to do its thing. It has gone ahead and put in place any number of statutes that pertain to real estate that govern how real estate works. And part of what goes on when you bring problems to real estate lawyers is that real estate lawyers themselves are thinking, okay, what's the answer at common law? Okay, has it been amended by statute? And is there anything in statutes? Is there anything passed by the Ontario or federal legislatures that may actually help me in dealing with this matter? Well, with regards to the federal legislatures, I chose not to tackle this, partially because under our Constitution, just so you're aware, none of you are here for a constitutional lecture, but under Section 9216, the governments in their wisdom made property and civil rights part of provincial legislation. This is the reason that the federal government, with very few exceptions, I think of mortgages and maybe prohibitions on purchase, and maybe criminal infractions under the criminal code, do not get involved, are not regulating our profession. This is the reason it's the OREA. The CREA is merely just a recommended body of laws that kind of is trying to standardize across the country, but it's the OREA that has larger effect. It is the provinces that govern real estate, so it is the provinces to whom I am going to turn my attention today and deal with legislation. I want to just preface this before I go into the slides. The legislation in Ontario is somewhat, well, it's immersive. There's a lot of it. We're not going to be able to deal with the entirety of legislation that exists and that pertains to Ontario today. Nor am I going to be able to deal with any of these acts that I'm going to talk about in any great detail. Instead, the goal of today is to flag for you that these legislations exist, such that if you find you are dealing with a problem, you will at least have it triggered that, hey, there is an Ontario statute that deals with this. Maybe I should give it some more breadth. Maybe I should give it some more investigation. So that being the case, we are turn our attention to the Ontario legislation that you should know. Let me enter full screen. There it is. And let me get cracking. Now, this is just the selection, as I say, of Ontario statutes that I would like you guys to know about. And we're going to talk about some of them in a bit more specificity, some of them just in general sense. But again, there's so much. This is more flagging it for you and making sure you understand. Let's start firstly with a piece of legislation called the Conance Property Law Act. So there's a couple of sections of this legislation that I want to point out to you. The first is something that matters. Section 13. It is the case that many lawyers, upon receiving instructions to register title as joint tenants, fail to do so. When they fail to do so, the law is very plain and clear on this. It reverts to tenants in common. So if, in fact, there is nothing that has been engrossed on a deed as joint tenants, then even if they have signed it as joint tenants, even if there's documentation to attest to it, it will be deemed to be tenants in common. You can, of course, go to the court, show them the evidence of what was intended, and perhaps get the courts to amend. But as a matter of course, for the purposes of the registry and for the purposes of everyone who's dealing with title, they must therefore interpret a lack of capacity as tenancy in common. More interestingly, I think, from a real estate agent's perspective, because a real estate agent has probably never really examined the Conveyance and Law of Property Act, is Section 15. I actually had a case in my office a couple of years ago where someone had gone ahead, sold a piece of cottage land, and then cut down trees, saying the trees were not part of the chattels or fixtures listed in the agreement. And they tried to sell the trees. In fact, they did sell the trees. And we said, thank you very much. They absolutely were part of the agreement. Why did we say that even though it wasn't there? Because Section 15 of the Conveyance and Law and Properties Act says that a conveyance, even if you don't mention it, includes all houses, outhouses, edifices, barns, stables, yards, gardens, orchards, commons, trees, woods, fences, hedges, lights, etc. I know we all write all electric light fixtures. Technically, lights actually go with a house. It says so right under Section 15, which is something that can be used. But this is all part of a normal conveyance unless otherwise stipulated, meaning that the reason you don't need to go ahead and run around and document all the things that are outside, whether it be sheds or barns or anything else, is because legislation already deals with that for you, Section 15 of the Conveyance Law and Property Act. If you know anything about severance, and I'm not here to talk about the Planning Act today, those of you who want that should be going with Ty, and she's just given a really good lecture to Stuart Title on that. But the Planning Act requires you to obtain municipal permission to sever mineral rights from land. Except that the Conveyance and Law and Property Act grants that you are allowed to do that from a severance as of right. Meaning that if you own, now don't do this on your own, obviously do this with a lawyer that specializes in this area, but it does mean that mineral rights, as a matter of course, can be severed from a conveyance. Someone can sell the underlying mineral rights separate and apart from the above ground rights as a matter of course by virtue of Section 16 and 17 of the Conveyance and Law and Property Act without having to go through municipal approval for that very severance. Quite important. Since 1950, you obviously can't discriminate. That should be very obvious. And I hope that's obvious, and I hope that we don't even really need to talk about that. And then Section 37 of the Conveyance and Law and Property Act is something most lawyers don't even know about, but it's a very, very interesting clause that comes into your career or will come into your career a couple of times. It's a curative clause. And what it says is that if a landowner makes improvements to lands that's not theirs, that they honestly did not know was not theirs, then they can place a lien on land of their neighbors that they have improved and get back the value of the input. There was a famous case about a boathouse that was actually constructed on what was believed to be one party's land, but turned out to be their neighbor's land. Suddenly, their neighbor ended up with this Muskoka-type boathouse that's worth like, a couple of $100,000. And Section 37 as the cure-all meant that that person who had invested hundreds of thousands of dollars into that boathouse could get it back by leaning the other person's land. So they were like, hey, you won the argument as to the boundaries, but because you won, I'm now entitled to my money back from this. And I'm bringing this all up simply because it's almost wondrous to me that we are agents and real estate agent or lawyers and don't understand that there's statutes that are mandating that we interpret our contracts and that govern law that is effectively governing the law of this area. And we don't really give it its time or its attention. I'm not saying no one knows about the Conveyance and Law of Property Act, I'm suggesting to you that if you speak to 9 out of 10 lawyers, none of them have read through it, and yet it contains very, very useful clauses. Something to look into, something to think about, something to research on your own. I'm going to pause for a minute, as I'm going to after every piece of legislation that's substantive, and ask if anyone has questions, and then I'm going to move on to the next piece of legislation. I have quite a bit to go over because there's a lot of legislation. Everyone cool on this? You can raise your hands or you can just chime in. We only have 45 people today, so it's not that big a deal. Okay, next. Beds of Navigable Water Act. Riparian rights in the common law, what the Bed of Navigable Waters Act is doing, in conjunction with another piece of legislation that we're going to talk about, the Conservation Act, it is codifying what is the common law. You may wonder where someone's borders are when they are dealing with lakefront property. Well, the Beds of Navigable Waters Act details it. And what it says is that if you're dealing with navigable water, that is to say a boat that's going from place A to place B, which is different than, say, a pond, then the boundary of the land is the low water mark. That's what the boundary is. You can have a survey, you can do whatever, but if the water mark goes lower, that's the boundary of your lands. And it also says that you can't go ahead and erect some form of boundary to the land. So as an example, I have cottage land where the water comes to a point and then continues to the stream. And it so happens that both parcels of land on either part of the stream are owned by the same party. That party is not allowed, because they own both sides of the land, to say, well, thank you very much, I'm going to put a net through the traveling stream, because that's a navigable body of water, and they're just not permitted to do it under the Beds of Navigable Water Act. Conversely, if you own a pond and say the pond is between you and your neighbor's lawn, well, the boundary is defined by this as the middle of that pond. And again, this may not be all that interesting to those people who deal with condo land out in Toronto or whatever it is, but I assure you, for those people who actually have cottage or rural properties, Beds of Navigable Water Act is a very, very important piece of legislation to know. For all of us, however, the Vendor and Purchasers Act is, well, first of all, any questions about Beds of Navigable Water Act? I'm going to talk about the rights to the flow of water in a minute through another piece of legislation.
Mark, sorry, just to clarify, those are only properties with riparian rights, correct?
With riparian rights, that's
So
correct. So it only pertains to places that are adjacent to water.
Thank you.
I mean, I guess technically it applies to all properties, but how useful will that be in your condo in downtown Toronto? I'm not sure.
Thank you.
All right.
Mark, sorry to interrupt, but what about the rule that the boundary is actually the demarcation point of the vegetation, not the actual high water mark?
I've never heard that. The Beds of Navigable Water Act says something very different. I'd have to look into it, Ty. I'm not an expert on this piece of legislation. If you know something different, I'm totally willing to be corrected on this, but just the plain reading of the legislation suggests this.
Yeah, no, Brian Madigan is always going on about how it is the demarcation of the vegetation on a shoreline that's actually the end of your property.
There is a Shoreline Allowance Act that I'm not dealing with here that may very well change matters from the Beds of Navigable Water, but I can tell you that the Beds of Navigable Water state this. There may be something in the Shoreline Allowance Act that changes that.
Yeah.
Okay. I don't know what the answer is, Ty.
Another thing that I find very interesting about the low water mark is the Trent system. They purposely drop the water down, usually in February and March, or in the fall, so that people can do work along the shoreline, like pouring concrete docks and things like that. So they do that temporarily, but I wonder if that's considered the low water mark.
You know what, guys? I wish I could answer. I'm not this type of lawyer. I don't deal with cottage properties. I don't deal with rural properties. This is not my area of expertise. And the mark of a professional is admitting when you don't know something, and I just don't know enough about this to comment. So
yeah, we should find
again,
a lawyer.
I'm flagging this for everyone because I want them to be aware that this exists. Those lawyers who are interested can do further research now that you know that this exists.
Cool. Thank you.
So the Vendor Purchasers Act is a really interesting one, and I am shocked at how many conveyance lawyers don't know the first thing about it or that it exists. Let me give you a scenario. So a title search is done. The title search basically says, all right, there's a noise violation complaint. We want it removed. The seller's lawyer gets back and says, thank you very much. We're not removing it for whatever reason, X, Y, Z. You knew about it. We had informed you. You would agree to take it subject to what? Who cares? They say no. The buyer's lawyer then basically says yes and writes back correspondence. And then the seller's lawyer writes back and says no, and so on and so forth. And letterhead goes back and forth. Well, letterhead is only good for scaring people and positioning. At some point, action needs to be taken. And in the process of dealing between a buyer and a seller when they cannot agree, there is an act called the Vendor and Purchasers Act, where the court is allowed to interpret any question affecting the existence or validity of a contract, and the court may make such order upon application as may be considered just. In other words, if the seller and the buyer disagree pursuant to their actual documentation and the title search and subsequent correspondence, getting a judge involved and getting a judicial determination as to who is right is a totally doable and foreseeable consequence. Interestingly, Section 3.1, until probably last year, was interpreted as not pertaining to adjustments. Our own Greg Whedon brought an application under Section 3.1, but a year ago or so, where a judge, regardless of the previous case law, saw fit to use the powers contained in Section 3.1 to adjudicate on erroneous statement of adjustments provided by the builder, and knocked one of the statement of adjustments right out of the park, allowing for a closure on different terms than what the new build seller was insisting on. Whoops, that's not right. There we go. Sorry, guys. Sorry. So a very, very interesting development indeed, because that reversed certain case law that says that they're not there to deal with adjustments. And he was successful in getting that through. You could speak to Greg about how to do it. Regardless, the Vendor and Purchasers Act is your ultimate recourse in ultimately dealing with errant sales. I'll give you an example of one is such example that happened in my office about a couple of months ago. It so happened that there was a back and forth between two agents who may be part of this forum, so I'm not commenting on what exactly happened, but I was representing the seller. And the buyer and the seller went back and forth, changing the purchase price of a property, only the purchase price of a property. Part of Schedule B stipulated that that there was no representation or warranty provided as to whether or not this was a single-family unit. It said so in Schedule B. It said so in Iteration 1 of the agreement, Iteration 2 of the agreement, Iteration 3 of the agreement, and so forth. By the last iteration, where finally the back and forth was always on price. Finally, the last iteration came back to the seller, and they said, all we've changed here's the final price. We agree, here you go. And they did not call attention to the fact that they had amended Schedule B. They did a quick one where they basically changed Schedule B to say, instead of does not represent and warrant, does represent and warrant that it is a single family home. And they did not call anyone's attention to it. No one noticed it. It was not initialed by the seller, but it was confirmation of acceptance was signed by the seller. And then the buyer basically said, we're insisting on a $60,000 reduction because you gave us a representation and warranty that this was a document, that this was a single family home. So the letter came from me 3 months before closing, and I wrote to them and I said, be advised that it's non-es factum. It obviously wasn't our deed. Be advised that you concealed this and you acted duplicitously. Good luck in court. But Also be advised that we are hereby denying your requisition on this point in advance, and this shall stand as our refusal to abide by your requisition. And if you have a problem, you have 2 months until closing. Bring your 3-1 application now. I am authorized to accept service. Let's go. Let's go. Let's put this in place. I don't want your correspondence 2 weeks before and then me coming back to you and saying, I'm just going to preempt it. I'm going to say, I totally understand where you're going to come with me, where you're going to go during your requisition. I am preemptively denying it. I am telling you I'm denying it. And under no circumstances do you say you do not have time to bring it. Now is the time to bring it. I am denying it. Bring your vendor purchaser application. And so it can be used in any number of very interesting ways if you understand how law works and how the process works. The point being, the Vendor Purchasers Act is there to assist you in the event that you and the buyer's lawyer cannot agree on something substantive. There is a lawyer, there is a judge who you can get before very, very quickly, well in advance of normal timelines, given that there's a signed agreement of purchase and sale coming up, often through triage court, which will allow you to ultimately work through your substantive problems. I'm going to pause. Does anyone have any questions about the Vendor Purchasers Act? Cool. Okay, Real Property Limitations Act. One of the first things I did in my career was I passed the Limitations Act. I was working in politics for an attorney general, and it was a funny story how we actually got it through. What actually happened was we got legislative, not that this matters, but just it's kind of cool how it happened. We got legislative time to put contingencies through, contingency legislation for lawyers through. And all three parties, the Conservatives, the Liberals, and the NDP, agreed to provide legislative time. And the moment we realized we had legislative time, meaning that no one was going to object and it was just going to go through the readings in like no time at all, we suddenly realized that we were able to bundle in two other major pieces of legislation with it, one of which was the Legislations Act. And so without anyone's knowledge, because this was just sitting around the Ministry of the Attorney General for like years, suddenly we realized in one night we were able to get the Legislations Act through. No one had any clue. And the next day, suddenly the Limitations Act had passed. And everyone was like, what the hell? And so we got it through. Anyways, the Limitations Act has certain exceptions. So the Limitations Act that you know of is the 2-year limitation, up to a maximum of 15 years for discovery, except in the instances of like rape and murder and certain things that are exempt. The other big exemption is with regards to real property. In fact, it was seen as too complex to include real property limitation time periods as part of the Limitations Act. And as a result, the Real Property Limitations Act has different timelines than the Limitations Act that all of us know about, that being the 2 years. So where there is an ownership issue in question, the time for bringing an action is actually 10 years. Similarly, the time for, say, if you want to contest your carry-on rights to get out of an agreement, that too is 10 years. There's case law on this. It's not 2 years. Mortgage arrears, 10 years. So if someone wants to claim that mortgage arrears are due and owing from 4 or 5 years ago, they can do so. The 2-year limitation is not a bar. It's the Real Property Limitations Act time period of 10 years that applies. There's also a 6-year limitation period for the recovery of rent, specifically enumerated in that. This is to say that if you are dealing with a land issue and you are coming up against your 2-year limitation period, you should be aware that there is a different limitation period for land, and you should be investigating it further. I doubt real estate agents are ever going to need this, but lawyers should be aware of it. Any questions before I move on to the next piece of legislation? We cool? We cool. Why is it that here? This is weird. Sorry, can you just give me 1 second, guys? Here, let's go here. View that as a full screen. All right. Nope, that did not work. All right, I'll just keep it like this. All right, so the next one that I want to deal with is the Conservation Authorities Act. Again, these things say so much more than I'm dealing with, but I'm just highlighting for you that these exist. Part of riparian rights under common law is both what type of property you own and what you can do with water that is flowing through your property. And it's a basic common law fact that you can't alter the flow of water, you can't alter the quality of water, and you can't affect downstream owners. And that has been solidified in the Conservation Authorities Act, which basically says that you cannot alter any waterway without express permission. You can't re-divert it through or around or anything else without specific permission from the ministry. All construction in floodplains must be approved. So if you are selling in a floodplain, you must make sure that you are able to get Conservation Authorities Act before you build. And it provides, along with other regulatory authorities, for septic approval. Septic approval must be granted. Septic, if you can imagine, is kind of poisonous once it gets going. It's ruinous to certain environments if it starts leaking. And as a result, making sure that you have a properly constructed, properly monitored septic tank is the bounds of the Conservation Authorities Act. And you have to be acting in compliance with that when you're purchasing rural properties. Again, I don't function in the rural property space. I'm simply calling your attention to the fact that these acts exist, and rural property owners must be familiar with these things when dealing with their properties. Similarly, there's the Environmental Protection Act. The Environmental Protection Act dictates that any industrial or commercial site in Ontario that is being converted to a residential or condo property, which is, what's happening across all of Lansdowne and the remediated lands across the TTC and a bunch of others, must in fact have a record of environmental condition. The way this works, agents on the channel, is that generally, if you're purchasing commercial property, because you want to adhere and you want to make sure that there is no environmental degradation, but more importantly, that it can be sold for residential purpose later on if you want, is to do what's called an ESA Phase 1 and an ESA Phase 2. To be clear, just for your own records, an ESA Phase 1 is a historical analysis of the land. Were there any gas stations, dry cleaners? Were there any contaminations that were known or anything else? And if you get a clear ESA Phase 1, then generally there's no need to proceed to an ESA Phase 2. An ESA Phase 2 is a borehole analysis that usually costs about $10,000 per borehole, and for a small piece of commercial land usually consists of about 3 boreholes. Which basically has a big machine that comes in, takes a soil sample, and then does a record of analysis to determine that there is actually no environmental contamination at the site, allowing for a purchase to take place. It is the case that a lawyer needs to understand the Environmental Protection Act very well and how the ESA 1 and ESA Phase 2 analysis takes place if you're in the commercial sphere. From an agent's perspective, properly drafting a clause for commercial purchase, particularly one which is dealing with large parcels of vacant land adjacent to areas that are that were used in the past for any number of purposes, is properly constructed, permitting an ESA Phase 1 and an ESA Phase 2 where appropriate, and remediation takes place afterwards. Those clauses are really important. Please speak to a lawyer who functions in this space. Again, unfortunately, you're dealing with a real estate conveyance lawyer in urban properties. So I'm not an ideal person to talk to about that. I'm simply pulling up the fact that this is an act that ultimately constrains and that we need to be well aware of. A similar piece of legislation that is important for those people in rural properties is the Public Transport and Highway Improvement Act. Sorry, first of all, anyone have any other questions about this? I kind of have skipped the questions because these are the areas I'm weakest on. So, I'm just kind of hoping no one asks, but I could try to answer.
Most real estate agents that are working in the commercial area should be aware that a Phase 2 is generally required by all lenders. So you really should put that into your agreement.
Absolutely. In fact, if you're in the commercial area and you don't understand what the Environmental Protection Act is or the ESA Phase 1, Phase 2, because you're a new agent or anything else, please, please, please secure the mentorship of someone who functions in this space. It's really very, very important to understand how borehole analysis takes place and the clauses that are necessary in order to protect yourself and to assure, as Kai said, your lenders. The Public Transportation and Highway Improvement Act is the reason that when you travel, and anyone crossed the border into the United States recently, and then when you take that highway from Buffalo, suddenly you're inundated by Cellino and Barnes advertisements every 5 seconds. Although not Salino and Barnes anymore because they've broken up. So now you get Salino and then you get another section for Barnes. Anyways, it's neither here nor there. It's not what today's about. You have a similar circumstance on the QEW, don't you? And the reason for that is because the QEW is municipally owned. It's actually not owned by the province, the QEW, up to the 427. That's municipally owned, and therefore Public Transportation and Highway Improvement Act does not apply. But where the Public Transportation and Highway Improvement Act does apply, you are not allowed to put up endless advertisements. It's a distraction to driving. You're not allowed to just add a property and give access to the highway because you have your property there. In fact, you're not allowed to build adjacent to public highways without appropriate permission, and there has to be appropriate setbacks. It is the case that a lot of people have found workarounds. One such workaround, as you probably have noticed on your trip up to Barrie, is a bunch of trucks that basically sit on land with advertisements on the side, but they haven't moved in 20 years because you're allowed to have a truck on the property and not an advertisement. But the whole reason that that our highways look much cleaner than they are in the States is simply because the Public Transportation Highway Improvement Act dictates what you can do around the land surrounding provincial highways. And if you're buying land surrounding a provincial highway, it's critical that you be going to a lawyer who understands the ins and outs of the regulations of the Public Highway and Transportation Act, because undoubtedly you're going to care about access points, you're going to care about construction and what can be done on these highways. And it is incredibly prescribed, particularly because the province is, in essence, trying to keep its ability to expropriate additional property such that they can expand the lanes in future years and to ensure public safety and to boot. So this is also, by the way, one of the pieces of legislation that has caused many families in Ontario to become billionaires. I think of our friends in Vaughan particularly, and perhaps with the last name de Gasperis, because if in fact you've restricted where people can get on and off a highway, and if you know where those exits are in advance of your average bear, which happens if you can place your family members within council or within the town planning departments, then buying up that land in the appropriate areas of land becomes a no-brainer and you become billionaires many times over. I'm not saying that happened, but P.S. it happened. And there it is. Vaughan has since cleaned itself up, but not before many people made a lot of money. Anyways, the Ontario Heritage Act. First of all, anyone have any questions about the Public Transportation Highway Improvement Act? Again, not trying to go into great detail. Each of these could be an hour-long course in and of itself. I'm highlighting for you statutes that you need to know as an agent or a lawyer here in the province while dealing with land. Any questions so far?
I just wanted to say that things like Highway 2 are actually highways. People will buy property thinking they can just put a driveway in and get onto Highway 2, and they don't realize the road that you're buying land on may not look like a highway, but may actually be one. So you have to actually know which roads are highways.
Yeah, Yonge Street actually turns into Highway 11, doesn't it? I mean, there's a point where it's Yonge Street and there's a point where it's Highway 11. Correct. Okay, the Ontario Heritage Act. So anyone like taking walks around Cabbagetown, the reason you do is because there is a designation of a conservation district there. You can't do anything to the properties. You can't really go ahead and build a brand new property. You must maintain the look and the facade and the feel and the heights and everything else. The Ontario Heritage Act is to some degree a bit of a killer. It's also a source of funds for a lot of real estate agents. It's critical that you examine title when you're listing a property. And if you see that something is heritage, it's really critical that you explore what that means. There's actually an Ontario Heritage, there's a Toronto Heritage Registry. It's actually very accessible, unlike most of Toronto's stuff online, where you can actually type in an address of a property and it will tell you what the restrictions on the property are. Sometimes those restrictions are facade-based. You have to keep the facade. Sometimes they're height-based. Sometimes they're just, you can't touch this property at all. And the designation of the property matters because obviously many times value of property is implicit in what you can do with it. And if you're restricted in doing something with the property, the value of your property falls. As a result, if you see anything in your title search that says Ontario Heritage, stop what you're doing, bring it to a lawyer if you're uncomfortable, or at least do your own research online. and bring it to the attention of your clients and say you should really speak with your lawyer before we make an offer to purchase on this, because you really need to understand what's going on if fundamentally you are restricted, if your acquisition is going to restrict you from doing whatever it is you want with the land. And you could just see endless lawsuits resulting. By the way, if you are an Ontario heritage property, you may ask why people do it. There is a budget that is allocated for Ontario heritage's properties to maintain upkeep, to maintain facades, to maintain the look. So actually, by virtue of designation, you actually get access to pools of capital as well. But again, well beyond the scope of today's discussion, I'm just bringing it up because I want you to be aware that this exists and it should be flagged for you as an issue. Anyone have any questions about the Ontario Heritage Act?
Can I just point out that there is a problem with the Ontario Heritage Act with rural community properties?
Sure.
Your property, you may be buying a farm and the house is fine, only to discover that the barn can't be torn down if you want to do redevelopment, because barns are also included in the act.
Ah, see,
Yeah,
didn't know that at all.
Yeah.
But there's a rule in our industry, people, called always listen to Ty. So anything she says is kind of gold. So when Ty speaks, you always listen to her. And if she's saying it, that's the case. So be advised. And again, the reason for lawyers who understand their areas are exactly the reason you're hearing here today. There's any number of acts, there's any number of rules, like Ty just brought up, that, you know, if you brought this to me, I would have no idea about the barns or anything else. And it's really critical to understand your area. An area I do understand very well is the Fraudulent Conveyances Act and the Assignment and Preferences Act. We live in a world where deals are now failing and builders are coming after you. Many people, in an effort to avoid litigation, shelter their assets. You should be advised that if you are doing so, there are court processes that can reverse those very actions. You are not allowed to shelter your assets in anticipation of evading creditors. Both of these acts deal with that. That is the reason why, if you're engaging in a risky business, it pays for you to remove the assets from your person in advance of engaging in those businesses, not when you end up in trouble. Because if you do end up in trouble, the trustees that are then acting on behalf of your estate, or those creditors who are coming after you, could functionally reverse them, even if you think that you've protected yourself, by virtue of them basically showing that you did this at the time when you knew or ought to have known that creditors were going to come at you. Yeah, you weren't served with an agreement of purchase and sale, but your friend was, and you knew that yours was in the mail, and you happened to transfer it that day. Not going to pass mustard. So be advised, Fraudulent Conveyance Act and Assignment and Preferences Act is going to be more and more in the news, because there are any number of people who, upon defaulting on agreements, immediately transfer all assets out of their name into their spouse or anything else. But there is legislation to guard specifically against that, and be advised it is used routinely. Let's talk about the Partition Act, which is something that I don't think a lot of people knew about prior to our forum, but we mentioned frequently on our forum, because the Partition Act is a piece of legislation designed to allow parties who are not amenable to moving forward with their ongoing joint ownership to divorce themselves of that joint ownership. It is the case that those people who are not in healthy familial relationships should probably arrange for a co-ownership agreement, which by design is designed to deal with what happens when the parties don't get along. That's the reason for a co-ownership agreement. Nonetheless, many people don't enter into it and suddenly find themselves with a 50-50 ownership of a property with someone with whom they don't get along. They make all sorts of reasonable suggestions. That person says, screw it, I'm sitting there with my hands crossed, not doing anything. The Partition Act provides for a mechanism to divorce yourself from that situation. You can bring an application to a judge and say, listen, judge, please decide on the basis of what is fair and let me either out of this or let me buy out my partner. And generally, the judge will basically go through an analysis and say, all right, who's ready to offer more for the property? Okay, very good. You can get the property and the other person has to sell after everyone has their due. And that's kind of the way it normally works itself out. It's expensive. it's elongated. This is the reason you should have an agreement in advance, but you should know it exists in the event that worse comes to worse and you cannot figure a way out of your existing relationship, the Partition Act. Anyone have any questions about that?
I've actually dealt with that in a divorce situation, and it wasn't all that onerous. It was very easy for them. And what the judge said is the property shall be sold for not less than the commission rate that will apply, and the wife's signature was not needed at all on any of the documents because they were being cantankerous about it.
Yeah, but that's not so that I'll bet you anything, Sandra, that wasn't a Partition Act application. I'll bet you anything that was an application under the Family Law Act. So the Family Law Act is dealing with spouses and gives judges the authority to divest property as well. The Partition Act deals with people who are not spouses and thus not subject to the Family Law Act. I would guess dollars to donuts that you were dealing with a Family Law Act issue given the scenario that you've just described.
Cool. I didn't realize that. Thanks.
Yeah. Okay, Road Access Act. So there is something which says that a private owner of land where a private road runs over it cannot arbitrarily prevent access to another person's lands by closing that road. You'd be surprised how often this actually comes into effect. It's not because there's a lot of neighbors that act in an arbitrary manner, but rather there are quite a few instances where someone has bought, unbeknownst to them, land that is effectively landlocked absent the road. And when they find out that the road is not owned by them and can be closed off, the value of the land plummets. Well, the Road Access Act ensures that that road will remain open and thus can be a cure-all if the buyer is ready to accept it and if the title insurer is ready to accept it, which they usually do given the Road Access Act, to gain access to the property. And some people are satisfied with the Road Access Act and they say, yeah, it's true I don't own the road, but it can't be blocked from me and I'm ready to move forward. Again, this is largely a feature of rural properties. I strongly suggest you get legal advice from lawyers who function in this area. I am, however, bringing up the fact that the Road Access Act exists because you should be aware of it if you're dealing with a neighbor that's cantankerous and closing off access, or alternatively, if you're dealing with a parcel of land where the only access is through someone else's land, you can make your client aware of it and say, let's go speak to the lawyer and determine if the Road Access Act is sufficient for your purposes to purchase this land. Very interesting stuff. Anyone have any questions about that? Ty, do you have any questions about that or comments? I have a feeling you know this much better than I do. Always use Ty.
No. Other than, water access is good enough, according to some judges.
That's true. And actually, there's a famous case on that where an easement of convenience is not an easement of necessity is not an easement of convenience. So you have to go 45 minutes through a boat to get to the land, but you can still do it. Anyways, let's keep going. I want to deal with the Boundaries Act and the Line Fences Act together. The Boundary Act and the Line Fences Act are basically arbitrations measures that have been imposed by the province where two surveys collide, where both people have gotten surveys that disagree with one another. And it has happened. It's actually happened in instances like where a cliff has fallen down and there's a new structure that has presented itself or something like that. The Boundaries Act basically allows for the province to arbitrate who actually owns what. And similarly, the Line Fences Act, which doesn't exist in Toronto, many municipalities have started to opt out of the Line Fences Act, but the Line Fences Act applies to most of Ontario. And what it says is that if there's a fence on a boundary that needs repair and one side is ready to do it or the other isn't, or one person disagrees the repair is needed, there's an arbitrator that can be appointed specifically to make an award as to what is to happen to that fence and who is to care for that fence because it's directly on the boundary line. One of the reasons that it's no longer that much of an issue is because smart people who are erecting new fences usually do so entirely on their property line by 1 inch, meaning that they're in control of the fence going forward. But I'm pointing out that the Boundaries Act and the Line Fences Act are easy ways of arbitrating sometimes disputes between neighbors on parcels of land that or items that actually affect both parties' lands. The Trespass the Property Act is something that I actually encounter quite a bit in the following scenario. Seller has until 5 o'clock to move out. Buyer approaches the property and suddenly seller is still there. Undoubtedly, all of you are familiar with that. The Trespass the Property Act basically says that you can be liable for a $10,000 fine. It also says that the police are specifically authorized to enforce against the trespassing party. I once had a seller that was just not moving. That's not to say they weren't getting out, but they had told us, oh, it's going to take me another 3-4 days to get out, yada, yada, yada. Here we go, whatever. We're not moving this fast. And I said, you have till 12 o'clock, and I called the police. The police came and said, this is a civil matter. And I said, it is not a civil matter. Here's my deed. They are trespassing, and here is the Trespass Act that shows that you are specifically authorized by virtue of the Trespass Act to remove these bumps. It says it directly. It says specifically that the province can take action and can levy a specific fine. Don't give me that this is a civil action. It's not a civil action. It's something where you're authorized by the province to act, and I'm putting you on notice that I'm expecting you to do it. And in fact, the policeman got a bit more irate. We called up their division boss. Their division boss got on the phone with the seller and said, if you don't do this, we're going to be pressing charges. And they didn't press charges. They just said they will press charges. And that was sufficient to get them out by the next morning, which wasn't satisfactory to my client, but whatever. They got their property the next morning. Next is Executions Act. When you go ahead and sue someone in court, all lawyers know this, but I'm speaking mainly to the agents here. When you go ahead and you sue someone in court, you get a judgment. What do you do with that judgment? Well, the judgment is converted to an order. That order then can be put against bank accounts, assets, whatever it is. But what most people do with the order, because it already has a level of interest that's going to accrue over the course of years or days, per diem amount, whatever it is, they register it with the sheriff's office. And the sheriff, in turn, is tied into the land registry, meaning that any single time that one person chooses to sell or purchase land, or any single time that someone chooses to go ahead and refinance their property, their name is run against the database pursuant to the Executions Act, which means that these judgments need to be cleared at that time. So it is the case that most people just sit quietly in the wings waiting while their judgment accrues interest. I would point out to the lawyers on this channel, I'm going to answer something pursuant to the Executions Act that all of you probably wanted to know. What is, as this is for lawyers only, so any agents can just close their eyes for a second or close their ears. What is the threshold for being able to accept your client's statutory declaration? We all know it's $50,000, but the real question that most of us get stymied on as lawyers is it $50,000 once interest has been accumulated, or is it based on the principal amount? And the answer, pursuant to case law, is it's based on the stated amount. It has nothing to do with the interest that is then accumulated, meaning that you can actually bona fide owe $67,000, 45 from a judgment and the remainder from interest, and you will only have to accept their execution judgment. You will only have to accept their affidavit, sworn affidavit, because the stated amount of the execution is $45,000. So just be aware of that. Most lawyers get stymied and they don't know where to turn when it comes to that particular bridge. And agents, if you don't know what I'm talking about, don't worry about it. All the lawyers know what I'm talking about there, and that's just for them. Okay, so we are now at 10:52 or so. There's a million other pieces of legislation. This is just a couple that I found that we could talk about. We could talk about this endlessly. There's so much legislation, but I wanted to pull our attention to the fact that these things exist. And part of the reason it's so important to speak to a lawyer is because even if you feel you know the law, any of these pieces of legislation could have stepped in and changed it or brought about color to the circumstance and situation. It's the job of a real estate lawyer to understand that these acts exist. It's the job of a real estate lawyer to go through these in detail and understand what the provisions are and say, hey, this is flagging something that may pertain to this legislation. And that is the reason that fundamentally we are asked to broach areas. It's not so that we can sit there and say, okay, what's the law? What's the case law? What's the common law? How's it amended by statute? And these are the things we are considering when these factors are brought to our attention. So that's what I have to say today. I guess I'm going to turn it to questions for the next 5 minutes, and then we'll call it to an end. Anyone have any questions that Ty can answer for you?
Hi, can you hear me?
Yes, Catherine, go ahead.
I'm a fairly new real estate agent, so a lot of that was over my head, even though it was fascinating. I guess my two main questions would be, where can I find more information to inform myself about this? Like, where do I go to read about these acts or learn about it? And B, can I just speak to a lawyer, or like, do they charge you just to talk to them?
So I'm going to answer the second one and then the first. So the second one is easy. Most real estate lawyers charge you to talk, but not conveyance lawyers. We're transactionally based. You're a real estate agent. Every real estate agent on this channel wants to speak to you and will talk your ear off and try to be your friend, specifically because you are the source of leads for them. So my suggestion to you is to get a good real estate lawyer, and my strong suggestion is to find a young one on our group, someone who is starting out. There's a couple of really good young aggressive ones, and become friends with them, because then you can just simply send them emails and say, hey, can I ask you a quick question? And then we're always available to answer, because that's how we get new business. So real estate lawyers are a bit different than other real estate lawyers, lawyers insofar as most of us are available to answer questions, and we do so in our own self-interest. In terms of figuring out and to learn more about this, the way a lawyer would learn more about this is there is books that are produced on the Ontario legislation pertaining to real estate that are produced by Carswell and some of the legal publishers that go through all of the legislation and detail it and talk about the case laws that pertains to it. It's a bit of a difficult read. There's nothing easy on it, but those are the books that I'm aware of that deal with this type of stuff in a sort of organized way. And if you want, I can try to find such books and kind of put up a link to it when I publish this. Oh, here we go. Thomson Reuters. There we go. I have one. Thomson Reuters has Ontario Real Estate Legislation 2022-2023 edition, and it's a portable and thorough consolidation of Ontario real estate legislation. I'll just share my screen. There it is. You can see it. So something like that is what a lawyer would use in order to familiarize themselves with all of this legislation.
Mark, my comment about the vegetation being the demarcation point, the reason for it is the beaches are generally considered to be part of the lake. And what ends up happening is when you say high water mark, the high water mark would be where the vegetation actually starts to grow. Interesting.
Okay, again, yeah. I don't know any of this, so I totally trust what you're saying, Ty. I didn't know that at all.
Yeah, it deals with beaches specifically, because the sandy beach is considered part of the lake, not part of the land.
Interesting. Again, another reason to use people who understand what they're talking about in these areas. All right, what's the next question? Someone else has a question for Ty.
Ha ha ha.
Come on, Ty, you know this better than I do. let's be honest.
I do have a question.
Come on, you can't be the one asking them. All right, fine.
No. Under the ESA, the Environmental Act, there was a change regarding the phase 2 requirements that happened, I think, about 3 years ago, and I don't remember what it was, but I remember, it's like most lawyers, I don't remember the details, but I know enough to remember that I have to flag it. So there is some change in the phase 2 environmentals that happened like 2-3 years ago, maybe 4, that you have to look into if you're dealing with commercial land, because there was a change in requirements.
Interesting. Guys, do not use someone who specializes in residential law for your commercial deals. Like, not all lawyers are created equal. And similarly, don't use your commercial lawyers for your residential deals. You'll massively overpay, and there's no point. Like, use the people who specialize in their area for their expertise. That's really a lesson that should be learned generally. And you guys are real estate, you know this in your own practices. Any other question? We have time for two more questions, and we're calling it a day.
Just a point for the new agents, I would highly recommend that you read through our group, go onto the YouTube channel, and while you're cooking or whatever, listen to the YouTube seminars that we have put on. There's valuable information in there, and it's a great way to learn new stuff.
And Catherine just asked, any young lawyers in here looking for a new best friend? So there's an opportunity to pick up a real estate agent. Catherine, what you're going to learn from that comment is never, ever, ever advertise yourself as a real estate agent looking to make a lawyer friend, because you'll make tons of them. You're going to be very popular. You're going to be very, very popular now. All right. Any last question? Who wants to take the last question, guys? We have one more question. That's it. All right, that is it. I wish you all the best. Well, this will be posted very shortly. Thank you all for attending.
Mark, one quick question while everybody else is leaving.
Yeah.
Do you know which law off the top of your head that, or if there is one, that real estate agents should not borrow money from their clients?
Oh, that's an LSO regulation.
Oh, that's LSO. Okay.
That's LSO regulation. That has nothing to do with law.
So,
like
so
the
that's
statute of the province.
Okay, so and that's just for lawyers then, not for real estate agents.
It's for lawyers. It's for lawyers.
Okay. Thank you.
All right. Thank you, guys.